The case set for trial is State of Lone Star v. Harley Bethel. Roscoe Herman. State v. Hunter.
All right, and is the state ready to proceed?
Yes, Your Honor, we have two motions in limine.
Is the defense ready? All right, let me have your motions in limine, please.
Your Honor, the first
Do you
motion.
have copies of the motions
Yeah,
for
sure.
me, please?
Certainly.
And you provided copies to the other side?
Yep.
Okay. Thank you.
Your Honor, may we approach?
You may.
Here you are.
All right, the motion, these are the motions that you actually file, or these are your arguments?
It's our arguments.
Do you have the motions that you filed and gave to them?
No, that's all we have with
Is
us.
it all you have? Okay. Well, we certainly need to work on that, keep Harvey running, I'm sure at some point in time somebody will listen. Okay, so, you've got two motions in limine. One motion is to exclude testimony that Harley Bethel used marijuana pursuant to Federal Rules 11-602, 404, 403, and 401. Does the defense intend to introduce such evidence?
It does not, Your Honor.
You do not?
We do not intend to use that.
This motion, can I have a piece of paper, because I can't really
Yes, sir.
write on these. Thank you.
May we approach?
Yes. So that motion will be granted by stipulation. Okay, the second motion from the state is a motion to exclude any and all testimony that Harley Bethel ever abused his wife. Assume the defense intends to introduce that testimony.
Yes, Your Honor.
All right, your argument, please.
Your Honor, by way of background, we anticipate that the defense will try to elicit testimony from Roscoe Herman and Kay Bethel on two separate directs, one on direct, one on cross, at some point in time. Pursuant to Rule 801, Roscoe Herman's potential testimony that Harley Bethel had abused his wife is hearsay and therefore is inadmissible. It's an out-of-court statement. It's an out-of-court. It was made out of court. It's a statement, and it's intended to prove the truth of the matter asserted that Harley Bethel in fact did abuse his wife. For that reason, it's inadmissible. Furthermore, Your Honor, pursuant to Rule of Evidence 404, evidence of a person's character trait isn't admissible to prove that on a different instance he acted in accordance with that character trait. In this case, the defense will try. We expect the defense to elicit testimony that Harley Bethel had abused his wife, and that he had a temper, and that it was more likely that he had a temper on the day that he ended up being shot and killed. This is textbook improper character evidence because they're using that character evidence and applying it to a separate occasion. Pursuant to Rule 403, the probative value of this testimony is substantially outweighed by the danger of unfair prejudice. The jury, if they were to hear testimony that Harley Bethel abused his wife, they would take that and quickly frame him as someone that beats his wife, somebody that is an abusive husband. And furthermore, there's no indication that at any time within a year of the murder that Harley Bethel had abused his wife. At any time within the year, I think a year is a substantial amount of time to consider for this abusive behavior. Any guess at a time frame within a year would be purely speculative. And so the testimony should be excluded pursuant to Rule 403. And finally, Your Honor, pursuant to Rule 401, the testimony isn't relevant. The testimony that Harley Bethel may have abused his wife at some time, it's unknown, and it's unspecified time, and it has nothing to do with the case at hand. The deceased victim is the one, is not on trial here. Rather, it's the defendant, and the testimony of Harley Bethel's alleged past abusiveness does nothing to prove or help prove any of the elements or any of the facts in this case.
Thank you. Response?
Yes, Your Honor. Moving on the first statement, Roscoe Herman's statement that Ms. Bethel kept telling her Harley was abusive is being used for a non-hearsay use effect on the listener. It's not relevant based on whether it was true, but the effect on Mr. Herman. Since Mr. Herman is presenting that he acted in self-defense, it is important for the jury to be able to understand his state of mind. Looking at the statement that Kay Bethel is going to make about her husband having a temper, under Rule 404A2B, there is an exception in a criminal case where a defendant may offer evidence of an alleged victim's pertinent trait. This victim's conduct is relevant since the defense is asserting that the defendant acted in self-defense, and therefore the defendant can introduce evidence of the victim's violent character to show that he was the aggressor. When looking at Rule 403, Kay Bethel specifically says on page 23 of her deposition, lines 13 through 15, that her husband had a tempter, and as the prosecution pointed out, this happened for it hasn't happened in a year, but it had happened in a specific period of time, which implies that the abuse was occurring prior. The evidence is extremely probative as it goes to the issue that the defendant was a violent person and that the victim was a violent person, the defendant would be justified in the use of deadly force if he believed such force was necessary. Kay's testimony that Harley abused her paired with Roscoe's testimony that Kay told him is highly probative of the fact that Roscoe knew or thought that Harley was a violent person. Roscoe's belief that Harley was a violent person goes directly to the reasonableness of Roscoe's belief that he was in imminent danger, which is central to this case. Any risk of prejudicial effect does not outweigh the high probative value. Under Federal Rules of Evidence 401, evidence should be admitted if it has any tendency to make a fact more probable. The fact to be proved that the defendant acted appropriately in self-defense is more likely to be true because of the offered evidence that the victims had a violent character. The evidence goes to weight, not to visibility.
Thank you. Pablo?
Yes, Your Honor. Just like mainly reiterate that the jury will use the evidence as character evidence, because, excuse me, that the evidence is hearsay evidence and doesn't necessarily fall under that exception, because the jury is going to hear that the out-of-court statement made to intended to prove the truth of the matter asserted that Harley Bethel beat his wife and therefore was a violent person. If that's the allegation, they're using for exactly what the statement means, and that's hearsay. And furthermore, Your Honor, the character evidence, well, yeah, that's all.
Okay. That motion is denied. Anything else from the state?
No, Your Honor.
Defense, do you have any motions?
Yes, Your Honor, we have two.
You
Would you
provided,
like copies?
you provided to opposing counsel?
Yes.
Thank you.
Can I approach?
Yes. Thank you.
Here's the first one, and here's the second.
Thank you.
Welcome.
You want to approach the bench to retrieve your arguments?
Yes, Your Honor.
Thank you. Okay, the first motion in limine from the state is a motion to exclude any testimony regarding the following matters. Let's see. Any evidence of the records of the Harris County Sheriff's Office that reflects that on May 28th, 2011, Kay Bethel attempted to file for a domestic injunction against Roscoe Herman, and any evidence that Mrs. Bethel was advised that the procedure was only available for one spouse to file against another abusive spouse. Does the state intend to introduce such testimony?
Yes, Your Honor.
An argument?
Thank you, Your Honor. First off, it is irrelevant under Federal Rules of Evidence 401 since Kay Bethel was not able to file the injunction, and even if she had been able, it has no tendency to prove the facts at issue in relation to the guilt of the defendant and is therefore not probative. If this evidence proves anything, it shows the state of mind of Kay Bethel, which is irrelevant. Even if this evidence does have minimal probative value, its probative value is substantially outweighed by its prejudicial effect, and it must be excluded under Federal Rules of Evidence 403. The jury will misuse the evidence as improper character evidence against the defendant. There is also a risk that the jury will be misled into thinking that the defendant threatened Mrs. Bethel, and this evidence does not support that.
Respond.
Your Honor, regarding the 401 argument, any fact or any piece of evidence that tends to make a fact any bit more probable, more or less probable, is admissible. The fact that Roscoe wanted Kay and Kay didn't want Roscoe around, which is the point that which is why she filed this police report. This is very important. It shows the great lengths that Kay went to try to keep Roscoe away from her. And as far as the argument for 403, probative value, in order for it to be excluded, the probative value must substantially be outweighed by unfair prejudice. The jury needs this information to help understand Kay's testimony and help understand that she didn't want Roscoe around her. I don't see any prejudice with this statement because the police report is not a conviction. It's simply an act that she went to try to keep Roscoe away from her.
The fact that, prosecution is arguing that Kay filed this report as to, the reason why she didn't want the defendant around could just as easily be argued that Kay Bethel filed the report at the nagging of her husband, who she told had been molested by this man. So there's a risk that the jury will be misled into thinking that the defendant threatened Ms. Bethel, and this evidence that she went to file it doesn't support that.
Thank you, the motion is denied. The second defense motion is a motion in limine to exclude evidence of certain statements made to the defendant's daughter. And specifically, the defense seeks to exclude any evidence that Roscoe Herman said to his daughter, Dana Herman, any statement resembling the following, quote, Dana, my heart isn't strong enough for prison, end quote. And also the defense seeks to exclude any evidence about when, how, or where the statement was uttered. Does the state intend to introduce such testimony?
Yes, Your Honor.
Argument?
Your Honor, that statement is irrelevant under Federal Rule of Evidence 401 because the statement is ambiguous, the meaning is unclear, and it contains no indication as to the defendant's state of mind. Additionally, the circumstances surrounding the way that statement was uttered, the defendant was in a state of shock or daze, and can remember nothing surrounding that statement, which supports the fact that it is ambiguous. It could mean anything ranging from on one end of the spectrum from guilt, on the other end of the spectrum to I think I'm going to be wrongly accused of this crime. And because of the statement's ambiguity, the statement has very low probability of value, but it has a very high probability of unfairly prejudicing the defendant. Despite the statement's ambiguity, both the content and the timing of the utterance shortly after the shooting are likely to be improperly used by the jury to directly infer guilt.
Response?
Your Honor, the best argument the defense made is a 401 argument that this piece of evidence isn't relevant. However, this piece of evidence has a huge probative value. It's highly relevant. I can't stress this enough. It's a large issue in this case whether or not this killing was legal or illegal. The fact that he uttered these words goes to show that he knew after he had shot him that or at least he considered the fact that the killing that he had just made was illegal. He certainly wouldn't have said, my heart isn't strong enough for prison if he thought he did nothing wrong. In the 403 argument, the probative value must be substantially outweighed by the danger of unfair prejudice. As I already discussed, this statement has huge probative value, and any prejudice would be minimal. And it's important to note that the person that will be eliciting this testimony, the defense will have the opportunity to cross them, and unless they elicit it from their own defendant, then they would have the opportunity to direct them. So any prejudice could be, if any prejudice is found, could be diffused.
Well, I'm pretty sure that it's prejudicial, just like all the evidence that you intend to introduce, or you wouldn't be introducing it. I mean, you're not going to introduce evidence that's going to help them.
Right.
I mean, I assume all the evidence, you keep saying the evidence is not prejudicial.
It's not unfairly prejudicial.
But I assume that the evidence that you intend to introduce is prejudicial to their side, yes?
Yes, absolutely.
Okay, the question is whether it's unfairly prejudicial. Of course, I don't know that they've actually raised, yes, they did raise the 403, so go ahead.
It's not unfairly prejudicial because this is something that the defendant said, he chose to say it, and when he declared it, it shows the declarant's state of mind. It shows that he understood that what he did was wrong, and this is very important. If anything, Your Honor, it goes to weight, not admissibility. The statement should be admissible, and the jury can do what they like with the statement in evaluating its value.
Rebuttal.
Your Honor, the state brought up a very good point. We don't actually know what it means. The circumstances surrounding that statement show that he may or may not have chosen to make that statement. There's a lot of ambiguity surrounding it, and because of that ambiguity, because there's no solid way to determine whether he meant it to mean an admission of guilt or whether he meant it to be speculation, we don't know, but it's so incredibly prejudicial, so unfairly prejudicial that the jury will hear it and forget about anything else.
Well, I'm not thoroughly convinced, or I'm really not convinced at all that the fact that you said, Dana, my heart isn't strong enough for prison is unfairly prejudicial. The jury may infer from this that he guilty knowledge, or the jury may infer from this that he just doesn't want to go to prison. He's afraid he might be falsely convicted. And what that tells me is that the statement made a moment ago by the state that this goes to weight rather than admissibility is exactly on the money. I think that the defense can, through cross-examination and argument, point out to the jury the argument that they seem to be making here, which is no one knows what he meant by that, or in fact, if he chooses to take the witness stand, he can explain the statement if he wants to do that, he doesn't have to, but he can. So the motion's denied. Thank you. Any other motions from the defense?
No, Your Honor.
Anything else from the state?
No, Your Honor.
Okay, any questions about anything?
No, Your Honor.
You are fortunate, I think all of you actually have been here,